Ilya Shapiro, welcome to Constituting America's Constitutional Chats. We are so excited to have you here with us today and honored, and are going to ask if you'll make a few opening comments on the Ninth Amendment, and then we'll go to questions.
Well, great. Thanks for having me. This sounds like a terrific series. And once you've gone through all of the amendments, and I hope you do the main part of the Constitution pre-amendment as well, this is going to be just a wonderful, go-to for anyone who wants to learn, especially, K-12 students who want to learn very quickly what the Constitution is all about. The Ninth Amendment is one of my favorite parts of the Constitution. Together with the 10th, they provide the summary of what the Constitution is all about. All right, Lacey has it up there. I'll read it. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That is, we have those first 8 amendments there. Well, just listing them does not mean that we don't have any others. It means we have lots more that are retained by the people. And can you click open the 10th Amendment there? This is why I say that this is a summary. On the other hand, so Ninth Amendment about rights, infinite number of rights, powers of the new federal government, not delegated to the United States by the Constitution nor prohibited by the states, are reserved to the states respectively, or to the people. So in contrast to the rights, which we can't possibly list them all, the powers in the articles of the Constitution, that's all the federal government gets. So it's a belt and suspenders approach. Now, this was controversial. When the U.S. Constitution was put to the states for ratification after being signed in 1787, the anti-federalists argued that a Bill of Rights should be added, because otherwise, we're going to have our rights invaded like we did by King George, the whole reason for the Declaration of Independence. Now, one of the arguments that the Federalists gave in response against the Bill of Rights was that listing those rights would mean that we're limiting those rights and indeed expanding those powers that we granted to the new government. Alexander Hamilton, who's known as a kind of having a robust vision of national power for the new federal government, says, "Why declare that things shall not be done which there is no power to do?" James Madison similarly was debating with Thomas Jefferson. We don't need to list these rights, otherwise people will doubt that we'll have other ones. At the end of the day, there was this compromise proposed by the Virginia delegation. And so after we had the initial rights in the Bill of Rights, there are actually 10. The first 2 didn't pass. Then the proposal, the compromise, was to say, well, look, with the Ninth Amendment, we're going to make clear that these rights that are very important that are listed, but that's not an exhaustive list. And similarly, just belt and suspenders, again, just to cross the T's and dot the I's, make crystal clear that those powers that we granted, that's it. So rights and powers work very differently. And to give an example, the Ninth Amendment doesn't come up very much in litigation at the Supreme Court or otherwise, because it only applies to the federal government. When we're talking about state violations of individual rights, we fought a whole civil war over this. And so you'll be talking about the 14th Amendment. Lots of different issues come to the court that are found, or debate is, whether they're protected by the 14th Amendment. The Ninth Amendment did come up in the context of parental rights, which is a common issue these days that we're debating, whether in terms of school curricula or which books go in libraries or what parents get to opt out of and all of these sorts of things. And there was a case in the year 2000 called Troxel versus Granville, which involved a Washington state statute that allowed anyone to petition the states for visitation rights, even if the parents disagreed. So in this case, it was grandparents. The father had died, the mother had remarried, the paternal grandparents wanted still to visit the kids. And the Supreme Court found the Washington law unconstitutional because it intruded on parental rights. Now, I won't go into the details because they're kind of convoluted and we don't have a clear standard. But on the losing side, Justice Scalia in dissent said, well, it may well be that we have all these rights, including parental rights, in the Declaration of Independence or in the Ninth Amendment, but there's no way to judicially enforce them. And so there is, among legal theorists, kind of a dispute over whether, even if the Ninth Amendment does protect our rights, is there a way to enforce it? But again, this is largely academic because most of the cases that come to the court about rights disputes are funneled through the 14th Amendment because it's claims against states. And those post-Civil War amendments fundamentally transformed our Constitution such that we had individual rights protections against states, not just against the federal government. I think I'll leave it there and look forward to further dialogue.
Well, thank you. That was a great overview. Really appreciate your comments. And I'm going to go ahead and go to Janine, who I think has got our first round of questions.
Yes, I have to be off camera today because my internet's being so strange. So sorry. I'm going to pass and come back. So I'm going to let everybody else, I'm going to do it differently today. I want to hear what everybody else has to say.
Sure. So then I can go. Thank you so much for sharing all your expertise. It's a really interesting amendment. I wanted to ask a more broad question, which is, what is a right? You mentioned we have an infinite amount of rights under the Constitution, but what does that actually mean? I know there are some theorists who say that people have a right to housing. Like, we hear that language a lot. You have a right to water, you have a right to healthcare. But I think on this show, we've talked about a different conception. There's also the natural rights conception. So could you just give an overview of what is a right? How is that defined by the court system, and maybe some opposing views of that definition?
Well, I'm not a philosopher. Actually, I didn't take any philosophy classes in college. I'm a simple constitutional lawyer. But off the top of my head, I would define a right as something to which someone has a claim against all others. And there are what philosophers have deemed positive rights and negative rights. That is, for example, if I have the right to free speech, then that doesn't impose any burdens on anyone else. I can just speak, and that doesn't require you to give me anything or anything like that. Or the free exercise of religion. If I'm exercising my religion, unless that means I have to kill you as part of my religion, at that point there's a clash of different things. But anyway, there's negative rights, and then positive rights. You mentioned the right to housing, or the right to a basic income, or there's some lists of these rights that 2 weeks of paid vacation, I think in the United Nations Declaration or something like that. Those impose duties on others. So if I have a right to free housing, somebody has to provide that. If I have a right to healthcare, well, doctors have to provide that, or taxpayers indirectly paying doctors. So it gets complicated after a while, and you can have government creating programs that give you, we call it a right under the law, but it's not the same as kind of a right in the state of nature, as it were, when we come together to form a government. What that government does and theories of legitimacy, that'll get you into even graduate school philosophy. But that's a brief overview.
Great, thank you. And then I wanted to talk about kind of going back to the establishment of the Bill of Rights. What was this responding to, the Ninth Amendment? What was the previous system like under England, and specifically referring to this idea that the burden is on the government? It's not just that, here are the rights you have and everything else the government can take away, but here, are specific rights you have, but only the things we give the government they can do. So where does that come from, and what was it responding to?
Well, this goes to the Declaration of Independence. This is broader than the Ninth Amendment or the entire Bill of Rights. The reason why the colonies revolted and why they declared their independence was they felt certain oppressions from King George, which they enumerated in the Declaration of Independence. Everything from taxation without representation, which you've probably heard about, to lack of control over our immigration policy, which you might not have heard. They were complaining that England would send them people, and they had no way of, saying we need more people, less people, different parts of the colonies, whatever. Anyway, lots of complaints about King George that they were subjects, not citizens, and they couldn't. They had a rudimentary House of Burgesses down in Williamsburg, for example, in Virginia, and different colonies had their little proto parliaments, but it wasn't really reclaiming for freedom or rights and things like that. And so they declared independence and said, there are these inalienable rights that from time to time we throw off the shackles of oppressive government to form a new government that will preserve those inalienable rights for us.
And And then I wanted to talk about, so in the context of the Ninth Amendment, I was wondering how legal scholars distinguish between enumerated and unenumerated rights, because under the Ninth Amendment, we have the right to both of them, but is there a more tangible legal distinction between rights that are specifically spelled out in the Constitution and ones that we simply like can't assume we don't have because they're not in the Constitution?
Right, right. Like I said, this is most of the discussion under the 14th Amendment because it's not very often that people claim a Ninth Amendment challenge or that courts entertain a Ninth Amendment challenge against the federal government without at the same time entertaining a challenge much more commonly that the federal government simply exceeded its powers, because those are, according to our constitutional structures, two sides of the same coin. And so in these discussions under the 14th Amendment about what unenumerated rights are and where they're protected, there's been an evolution. So 5 years after the 14th Amendment was ratified in 1868, the Supreme Court essentially wrote it out of the Constitution. And so in the latter half of the 19th century, we had all sorts of state oppressions that unfortunately federal courts did very little about. And then early in the 20th century, the Supreme Court started what lawyers call incorporating various rights against the states. So piecemeal, free speech applies against the states. The right to be free from unreasonable search and seizure under the Fourth Amendment applies against the states. So piecemeal throughout the 20th century, those rights were applied. Well, what about unenumerated rights? Because in the 14th Amendment, we have the Due Process Clause, the Privileges or Immunities Clause, and the Equal Protection Clause. And there are debates among scholars about which of these clauses protects which right, which protects more of these unenumerated substantive rights as opposed to procedural rights. But that's where the battle is, where you're talking about the right to privacy, whether that's sexual privacy or anything else, whether you're talking about parental rights, whether you're talking about anything that is not explicitly written down in those first 8 amendments. There are debates about is this right integral to our history and traditions, to our system of ordered liberty, for example? And courts the Supreme Court has set these standards for determining whether there is that right.
And then following up on a more basic level, could you just compare and contrast the Ninth Amendment and the 14th Amendment? Like, why is it that claims that could deal with the Ninth Amendment can be funneled through the 14th Amendment? And why wasn't it that the Ninth Amendment could have just been incorporated to the states? Like, why did it have to be addressed with an amendment, which is really hard to do?
So the first 10 amendments were only applying to the federal government. Until the 14th Amendment, until after the Civil War, if a state government or a city or municipality, county, what have you, was censoring you or taking away your guns or sending in police to ransack your home, you did not have recourse in federal courts for that. Those protections were only as against the federal government. And so it took the post-Civil War amendments, and especially the 14th Amendment, to have those protections against the states. That's the big difference. Another difference is that the reason for rights protection shifted as between the late 18th century, when concerns were about government tyranny and the return of King George and a tyrant and things like that, versus after the Civil War, when there were concerns about lynch mobs and political minorities of any kind based on race or otherwise being oppressed or discriminated against in terms of legal process in all sorts of states. So if you're doing originalism, if you're looking at trying to understand the meaning of the Constitution, a constitutional provision according to its original public meaning, you have to do that at the right time. So the 14th Amendment was enacted in 1868, and you look at contemporary debates in Congress and otherwise to see what the due process means. Whereas for the Bill of Rights, which was ratified in 1791, you look at the Federalist Papers, you look at the debates around the founding.
Great, thank you. And then just for my last question, when Kathy was reading out your bio, it seems like you have a lot of experience, first of all, studying abroad, but also working in international relations. So I was curious, on a more personal level, like how has this international approach enhanced your appreciation or understanding of the Ninth Amendment? But also, like, on a more factual basis, what is that system like in other countries? Is there this understanding that, you know, the government has these enumerated rights and they don't have the right to everything that's not enumerated, but we do? And like, what does that look like in countries that don't have that?
Well, the Anglo-American system is different conceptually than the continental European system, and then there are wrinkles obviously in other types of countries. In general, I think if I had gone into academia straight out of school, I probably would have gone into comparative constitutional. So I find it fascinating to compare how different political and legal structures evolved in different countries, how that relates to their cultures or whatever other reasons. There's not really something like a Ninth Amendment or these kind of, we reserve these background rights in many places. And indeed, the power side, even more so, there are striking differences where the national government essentially has the same sorts of powers that we think of states having, which are broad powers to regulate for what are called the police powers, to regulate for the health, safety, welfare, and morals of society. In most countries, including federal countries like Germany or Australia, the national government has those kinds of broad powers without that belt and suspenders backup of the infinite rights versus limited powers provisions.
Well, thank you very much. I'll pass maybe back to Janine if you want it, or to Jewel and Jordan, but thank you for your time.
Thanks, Tova. Yeah, well, Jewel and Jordan, y'all go ahead. I'm having fun just listening. I'll get and formulate a question or two at the end.
Okay. So first of all, could you tell us about some of the early challenges regarding the federal government overstepping, or a claim of the federal government overstepping its rights and some court cases we should know about if they were read to the Supreme Court?
Well, there weren't too many Ninth Amendment cases. Kind of the one that gets talked about is one from 1947, actually, called U.S. Public Workers versus Mitchell, which said if granted power is found, necessarily the objection of invasion of those rights reserved by the Ninth and 10th Amendments must fail. Which means that if there is a granted power to do something, then by definition there can't be an invasion of rights, because the federal government was only granted powers that did not invade people's rights. And so the early debates over constitutional structure involved, whether the federal government had the power to do something, and what the relationship was between the federal government and the states, and making clear that the Bill of Rights was only enforceable against the federal government, for example. So really, it wasn't until, there are plenty of debates over federal powers. Can the government create a Bank of the United States, which was a big deal in Andrew Jackson's day in the 1820s. There were court decisions going back and forth. But all of these things, again, the Ninth Amendment is kind of lurking in the background, because the idea is if the federal government has the power to do something, then by definition, under a fair and logical reading of our constitutional structure, that's not an invasion of our background rights under the Ninth Amendment. So sort of always lurking in the background without really being adjudicated.
And it wouldn't be adjudicated because they would be trying to find that power within some other element of the Constitution. So you wouldn't be going directly to the Ninth Amendment, you'd be going somewhere else to look for it.
Right. There's a reason why certain amendments were listed, because those are the ones that were most commonly violated. Allegations of censorship or disarmament, or there was a real concern about the forcible quartering of soldiers that happened during colonial times. We think the Third Amendment is an afterthought, but that was a real concern in the 1770s, 80s, 90s. And so there was litigation over those provisions, but the Ninth Amendment was not invoked because people weren't so much thinking about background rights. The federal government was relatively weak, and so didn't even have the power to tax incomes or lots of things that we think are federal duties at the time. Before the Civil War, the federal government was rather small, and all the action was in the states.
It's interesting because we have talked on the show before about a originalist viewpoint of the Constitution, and other viewpoints of the Constitution. But simply it's a truism that when it was written, it meant what they believed it meant. And then from there we can interpret it today how we'd like. But we basically can see how the Constitution was acted upon at the time of being written. So it is interesting to hear about the cases that had come forward from that time. But I wonder what they included an amendment. They included this Ninth Amendment, which clearly says, hey, you got no powers that are not listed. And then we
No, that's the 10th Amendment.
So that the Ninth Amendment saying that the powers that are not listed in
No,
here.
that's the 10th Amendment.
Okay, so which one's the ninth?
That says that the rights that are listed here are not exclusive, that we have other rights that are retained by the people.
Yes, but the rights that are not listed here are the states.
No.
Which one? So the ninth is, can you say that?
Ninth is about rights. The 10th is the rights are infinite. The 10th says federal powers are limited.
Limited by
what's granted in this Constitution.
So limited by what's granted by the Constitution, and if it's not listed, it's the states.
Then it's retained by the states and the people.
That's the ninth, correct?
That's the 10th.
So what's the ninth?
Rights are infinite.
That's it.
Yes.
And then the 10th is the second part.
Yes.
Okay. So the extension of, so were there more cases than where the 10th Amendment is what comes into question?
Well, I don't want to steal the thunder of whoever your next guest is to discuss the 10th Amendment, but again, the 10th Amendment as such was more litigated more in recent times because the actual powers were litigated themselves. So there would be a case saying, well, you don't have the power to regulate this ferry that goes across Lake Champlain because that's not interstate commerce or something like that. That's not one of the powers we gave to the federal government. So again, the 9th and 10th Amendments weren't litigated so much because they were recognized as being the belt and suspenders. They weren't really needed. They were just underlying the point and making the compromise to allow the Bill of Rights to happen, to say that, look, we're going to list these rights, but let's be clear, we have lots of others. On the other hand, let's be clear that those powers that we already listed, that's it. We're not giving the government any more powers than that. So that's the way things work.
Lacey, could we pull up the 9th Amendment again for everybody, just so we can be clear about the full amendment?
One quick second, I'll have it up.
No problem. Thank you. So it is.
Yeah, just so could you use the term that rights are limitless? Could you just explain that a little bit further for the audience?
Sure. I mean, it would be impossible to list all the rights we have. I have a right to walk on the right side of the road. I have a right to get out of bed on my left foot while wearing a red hat. I have a right to, I mean, you catch my drift. There's like any little thing. I have a right to turn my laptop in a counterclockwise direction right now as I'm talking to you. All of these background rights that, no rights are absolute. The government, if it wants to stop me from turning my laptop in a counterclockwise direction while wearing a red hat, it better have a good reason to do that. But those are the sorts of, background rights why we couldn't possibly enumerate everything.
Yeah. So in the 9th Amendment, when we're looking at the certain rights shall not be construed to deny or disparage others retained by the people. Could you put that instead of being something more just like a trivial, walking in a circle or something like that? Can you put it in more of a meaning?
Economic liberty, the right to earn an honest living, the right not to be, restricted from peaceably
so certain
carrying out your
rights shall
trade.
not be construed to deny or disparage others retained by the people.
The enumeration
Obviously,
of certain rights. So listing these rights, don't understand what we're doing here to mean that by listing these 8 amendments that we're disparaging other rights that we retain, that people retain.
So in a practical way, that may mean that listing the right to keep and bear arms does not then deny or disparage some other right, because this rights list is not exhaustive.
Right. It's not saying that, these eight 8 rights: the right to free speech, freedom of religion, right to keep and bear arms, right to not have property taken away from you without just compensation. All of these rights. It's not saying that these rights are more important or kind of super rights and everything else is secondary.
And that leads me to kind of back to where I was trying to go in the beginning, which is that it basically references the concept of natural rights, and we're coming off.
Yes, the Ninth Amendment is very much a natural rights kind of provision,
and a law system that may deviate somewhat of the common law from where we would have pulled much of our ideas, building off of a Magna Carta heritage and implementing new American ideals and ancient ideals as well. But with a common law background and a natural law background. But in today's legal climate, we don't find natural law anymore. And in fact, we find much more lawyers. We've had people come on before, awesome, podcast guests who've told us about how lawyers don't even study natural law at many law universities.
Natural law is a little different than natural rights. I mean, I don't want to broaden this discussion to get into metaphysics and all that, but natural rights is just the rights that we have in the state of nature, and we only restrict those rights based on the powers that we give to the government that we find necessary to secure and protect those freedoms for us.
Yeah, and it's going to be hard it's hard for our Constitution to be expressed effectively in a legal system, which then has left expressing those rights of natural rights and push that out of our adjudication pretty much in legislation, in law of most of any kind. And we're going to find a great striation of meaning across the entire nation. As we've seen, as we follow federal court cases, we can find this court ruling this way, this court ruling this way, this court ruling this way, and there's very few linking, unifying threads. And it's why, the American people are feeling a great amount of stress put on them, feeling like something is uneasy in our court system. I mean, on both sides, we have the same argument basically. And it's interesting that in this right, we strongly assert how we have the naming of these rights is not to say that these are the only rights people have. And implicitly, that means that we are a natural rights system. So it is important for us to understand the framing of our founding documents and what makes them effective or ineffective.
Well, sure, but as I said, most clashes with rights, most challenges to them happen against what states do, not what federal government does, and so that is a slightly different conception, because moving from the 9th to the 14th Amendment, the 14th Amendment isn't purely a natural rights conception. Certainly part of that, but there are other civic rights about juries and other civic institutions that have already been part of the government for so long. They weren't constituting a new government; they were tweaking how the relationship between the citizen and the federal government, the federal and the states, and the citizen and the states, and not writing on a blank slate. And so the conception of the 14th Amendment and specifically due process and privileges or immunities certainly is part of the natural rights tradition, but there's both more and less than that.
Would you agree that the Ninth Amendment is almost our founders covering their fallibility?
Well, like I said, it's a
Doing that they're not perfect and they will miss things, so that's why this amendment was really written.
I mean, not their fallibility. I wouldn't put it that way. I would just say that again, to have a Bill of Rights, they needed to have this compromise, because the Anti-Federalists and Thomas Jefferson, who was not an Anti-Federalist, were very concerned that enumerating rights. So the Anti-Federalists were concerned that not enumerating a Bill of Rights would allow the federal government just to grow and grow and grow and invade our rights. And so we needed to put down some markers. And in response to that, Hamilton and Madison said, well, I see dangers going the other way. If we have this list, then the federal government will really grow out of control, because we're saying, that's it. And so, like I said, the Virginia delegation put up this proposal to make it clear. It's redundant. Lawyers don't like redundancy, but they felt it was warranted here as a compromise. Okay, we'll have the enumeration of the rights, which I think was good, because I think the Anti-Federalists were right that we did need some enumeration, as we've seen the federal government has grown a lot. But I'm glad that we had these fail-safes, these redundancies, that the rights are not limited to what's listed, but the powers are limited to what's listed.
Thank you. I think it's time we pass to Janine for her questions.
Thank you. Thank you. This is a wonderful conversation. I'm so excited to be listening to this, and thank you, Mr. Shapiro, for all of this. I mean, it's amazing how simple these amendments can be and how complicated they can be at the same time. So I've been writing notes here, and I really love the 9th and 10th. I think the first is fundamental. So much, they're all important, of course, but the 9th and 10th, I like this catch-all. It kind of, like you're talking about the 9th and 10th go back to what they originally thought. Well, you don't need to number them. And I say number for the students that are listening that might not know what enumerated means. You don't need to number them, because we're very specific about we can and can't do. So we're not, but they kind of got their wish anyway. They went back to say, you have all this, even if it's not listed. But I'm going to try to formulate a question here. I think that, federalism is where you have the national government, but the states retain a lot of their own power. And the 9th and 10th, one of the reasons I really like it is because the 9th is giving the people the power. Don't forget, back to the Declaration of Independence, the people, you have these rights, but also with rights, you have power, like freedom of speech is power and freedom of the press is power. And the 10th, of course, gives it back to the states. I'm curious about then the 14th Amendment, because as you were saying early on, the 9th and 10th is about the national government. Okay, and I think a great example of this is religion. Congress cannot establish a religion, or prohibit thereof. But states could. States could say, we're going to be Anglican, and you had to pay a tax to the Anglican Church in the early days. But the federal, the national government couldn't. And then the 14th Amendment comes in. So, and it says, well, actually, I'm interested how much the 14th Amendment covers, because I started thinking about, say, taxation. And the federal government's, the amendment says, okay, we can tax. So we're going to start taxing you. But it doesn't talk about state taxation. States can still do whatever they want, but they can't do that with certain other powers in regard to the 14th Amendment. So where's the line drawn between, Congress cannot establish a religion, that was national, and states could, and the 9th and 10th protected all that. But where's that line drawn with all the other amendments after 10?
Right. So the 14th Amendment has been, over the years incorporating almost the entirety of the Bill of Rights. And occasionally you still have parts of the Bill of Rights that just were not treated. I think it was just 2 or 3 years ago that the excessive fines clause of the 8th Amendment was finally applied to the states, incorporated against the states. Now, the whole notion of incorporation, I think, is a constitutional misnomer or malapropism from an academic perspective. If the enactors, the ratifiers of the 14th Amendment, had simply wanted to say, okay, amendments 1 through 8 now apply to the states, they could have written exactly that. They had the capacity of the English language to do that. They didn't do that. They instead talked about due process and equal protection and the privileges or immunities of citizens of the United States. So in effect, they were providing protections that were both greater and lesser than the Bill of Rights, although that's largely an academic point. It's now read as being concomitant, the same protections for the Bill of Rights against the federal government effectively apply against the states. And the 14th Amendment did much more than that. When we're debating whether Donald Trump can be disqualified from the ballot if he was involved in an insurrection or what have you. That's part of the 14th Amendment as well. Nothing to do with what we've been discussing, but the 14th Amendment was a bit of a catch-all, involved the validity of the public debt relating to Civil War debts and things. So there's lots of stuff there that was sort of cleaning up and recalibrating the American system in light of the problems and weaknesses that the Civil War revealed, apart from slavery. Getting rid of slavery was the 13th Amendment, relatively simple language. The 14th had a lot of different structural things. So the 14th neither grants nor takes away state powers, because states don't get their power from the federal Constitution. They get it from their own constitutions, and they have, as I said, these background powers to regulate broadly for health, safety, welfare, and morals. So it works a little differently. But the 14th Amendment did put certain restrictions on states in the sense that individuals could go to federal court if they felt that their states were violating their rights, whether that right was enumerated, listed in the first 8 amendments or not, whether it was an unenumerated background, natural or other right.
Right. So primarily the 14th Amendment, if I understand what you're saying, was in relation to the Bill of Rights.
No, the 14th Amendment was saying that for the first time, you can go to, if you're an individual who's being oppressed by a state, who's you're alleging your rights are being violated, whether that right be the Bill of Rights or whether it be unenumerated, whether it be due process or equal protection or the privileges of citizenship, you can then go to federal court. Whereas before that, you could not. You're simply out of luck, and states were completely sovereign within their territory.
You know, we've often talked about how the 17th Amendment radically changed things, but really the 14th did too, because it really puts a damper on 9 and 10, which is saying
no, not at all. It expands the 9th Amendment in effect and applies it to the states because again, you have federal constitutional protection for rights violations by states.
But it takes away states' power. You can argue whether that's good or bad, but what I'm saying is it's taking away the state's power.
Well, it limits states' powers only to the extent that the states are violating individual rights. It's not saying that states, have less of a income tax power, or less of a property tax power, or less of a power to, regulate stores or have organized police forces or anything like that. They're just saying whatever states do, if an individual feels that you're violating their constitutional rights, they now have a claim for it.
Yeah, I think maybe what I'm thinking is I'm not thinking about rights per se, just the structure of the government changed. Because
absolutely. It's known as the post-Civil War amendments were known as the second founding because they reconstituted the relationship between the states and the federal government and citizens with both of those.
Right. I think that's what I probably said that poorly, but I think that's really what I was focusing on, because the 17th radically changed it. The Senate is no longer appointed by the state legislatures, but really the 14th radically did too. And I'm not making a judgment it's good or bad. Of course it's good, but it radically changed things. And explain the difference between if the 9th and the 9th and 10th and then the 14th, they just all go hand in hand. So it's saying states we're going to pass this amendment, but the states have to abide by this too, which is obviously what happened with the Civil War. But let's filter through the others, like the 19th Amendment. Women have the right to vote. Well, that all the other amendments still affect all the states.
Well, not all the other amendments necessarily. That one certainly does.
Have the right to vote.
The 16th Amendment only affected the federal government giving the power for a federal income tax.
Okay, well, maybe not all of them, but if we go through like taxation, women's rights, women's right to vote, the voting age, things of that nature, they supersede the states. They trump.
Well, again, you have to take each one by one. So, right, women voting or not denying the vote based on sex, not denying the vote based on if you're over 18. Those do affect. Once they were constitutionalized, they certainly affected state elections as well as federal.
because the 19th Amendment was passed a lot of by state. Well, the states passed women's right to vote in a lot of states before the federal government did it.
That's
so
right. I mean, there's a similar story to be told about the 17th Amendment, actually. About half the states were already sending senators who were, the legislature essentially ratified non-binding plebiscites by the people, and things were heading in that direction in general. I mean, I agree that we'd be better off having senators as representatives of their state governments rather than duplicating the House. But I think the way that the political winds were shifting, for practical purposes, I think we would have gotten there regardless of the 17th Amendment.
Yeah, well, really, really interesting. But I'm just intrigued about how the 9th and 10th have any power anymore, because it seems to be when amendments are passed, you just mentioned, of course, ones that don't flesh out the states, but they seem to really flesh out the states and then say we supersede, which of course the Constitution does anyway. The laws enumerated in the Constitution are supreme against the states. But in regard to all these amendments, I guess the difference is 1 through 10 was about rights, and all the rest are just about government per se, but really not, because do you have a right to drink alcohol? Do you have a right to vote? Do you have a right to vote before you're sent off to war? Those are personal rights too. It's just really interesting to me. I feel like the 9th and 10th have really been obliterated pretty much.
Well, I mean, it's not, again, the 9th and 10th Amendment are redundant of the overall government structure, which indeed has been skewed in that we're starting in the 30s or so, we've allowed the federal government to do things which I would certainly argue are outside the scope of the Constitution. The so-called switch in time that saved 9 in 1937, where the court started approving certain New Deal and other economic regulatory programs that it had been invalidating for a long time. And similarly with rights were bifurcated such that some rights are more equal than others in effect. Also in a case in 1938. And that's why people call it the Constitutional Revolution of 1937. Wickard versus Filburn, a case in 1942 that allowed the federal government to regulate the wheat that farmers grew in their own backyards for their own consumption, because that was part of a national market for wheat at the time under agricultural regulations. Yeah, over decades, we have seen the growth of federal power at the expense of federalism, at the expense of the states, and ultimately at the expense of a cabining, a narrowing of the freedom that individuals enjoy. But that's not just because of the 9th and 10th Amendment. Like I said, 9th and 10th Amendment are the flip side of the rest of the way that the Constitution was originally conceived.
Mm-hmm. Well, of course, the 14th Amendment was for very, very good reasons. It almost seems like if they'd been more specific, then government might not have grown quite so much. If it just been specific to slavery or to voting rights.
Well, yeah, well, but they weren't only concerned about slavery and voting rights. The slavery was the 13th Amendment, voting rights was the 15th Amendment. So, there were greater concerns. There were concerns about sharecroppers being dispossessed of their firearms. There were concerns about Asians who built the railroads in the West that were having their personal belongings stolen from them and zoned out and things like that. There was concerns about Southern sympathizers in the North and Northern Union sympathizers in the South, and everybody getting the local sheriff having a posse to beat them up and things like this. I mean, this was the country was fractured, to say the least. It just fought a civil war. There are a lot of issues to deal with, and the Reconstruction Congress said, we need to fundamentally reconceive how all of this works and make sure that individual liberty is protected in a way that goes far beyond simply dealing with slavery, America's original sin, or the implications for freed slaves on elections.
Mm-hmm. Fascinating. Well, I'm going to toss it to Kathy. I'll just summarize. I do find it fascinating. It needed because it needed to happen, but essentially states did lose their rights.
States don't have rights. States have powers.
Yeah, right. Okay, states lost their powers. Thank you for that correction. States lost a lot of their power. So federalism really took a, a, a bite there.
Not really, because it wasn't rebalancing federal versus state power. It was protecting individual liberty. So to the extent state powers took a hit, only to the extent that the states were using those powers to oppress individual liberty.
Okay, cool. Really
And the
interesting.
reason why I specified, by the way, that it was state powers wasn't to be trite or pedantic, but just because one, as a matter of political philosophy, that's the precise understanding. But also, when you talk about states' rights, that harkens to the segregationists in the 50s and all that, and it's just there's no reason to commit an unforced error to talk about states' rights when states don't have rights.
No, I really appreciate that. I think I'll walk away from this discussion really remembering that, because I think we use the word states' rights all the time. And so now I will always remember you in this moment, and how to say it differently, which is states' powers. Really, really. No, that was, I always say it's that answer on the test that you missed where you learn the most.
There you
know,
go.
always the ones that you get right, you don't always remember, but it's the ones that you a discussion happens and the light bulb goes off. So thanks for that. I think that's really, really interesting. Well, I'm sure the audience has a lot of questions, so I'm going to pass, but thank you. Fascinating discussion. Thank you so much.
Yeah, thank you to everyone. Great questions and great discussions. First, we want to give a shout out to our teachers and students who are watching today. D'Angela Hines has students from Emerald Coast Christian Academy. So welcome, Deanna, and your students, D'Angela and your students. And if you are a teacher with students and you'd like a shout out, type in the Q&A and we'll be sure and give your classroom a shout out before the end of this chat. We also want to thank our listeners in Las Vegas's KKVV 1060 AM. KKVV airs these podcasts on Monday evenings at 6 p.m. Pacific. So thank you, all of our listeners in Las Vegas's KKVV. So just going back to this whole issue of governments having rights or powers, which we just talked about, but one of our listeners asked that question, actually. I think it's probably worth repeating. So Robert asked, does the government have rights or does it just have powers? Conversely, do individuals have powers or just rights? And I thought that was an interesting second part of his question.
Well, yeah, we answered that first part. The second part, individuals don't have constitutional powers, right? Nothing that I can do because the Constitution, either the federal or I'm in Virginia, the Virginia state constitution gives me the power to do that. I have the right to do certain things that a law might give me that right. Again, there's this negative and positive rights distinction. So no, I don't think people have powers in the legal sense. But you do have the right, you have your natural rights, your constitutionally protected rights, but then under federal or state law, you might also have the right to, I don't know, the different, in different places, they give you different rights to do something. For example, we have a swimming pool and the municipal water authority gives us the right to fill the pool within like a 5-day window at a lower rate than normal. It can get technical like that.
Interesting. And then Robert also asked, do rights apply only to citizens of the United States, or do they apply to people who might be here illegally or to felons?
It depends which right. So everyone has the right to free speech or to freely exercise religion, basically negative rights. But civic rights, you don't have the right to vote or serve on a jury if you're not a citizen. Now, there are some rights that green card holders, permanent residents have that tourists don't. And so there are distinctions like that. And for that matter, as we're seeing this has come up, I wrote a piece last week on anti-Semitism and the First Amendment, especially on campus. Foreign students have the same speech rights as American students, but your visa can be pulled if you're supporting a terrorist organization. So there can be collateral consequences that have nothing to do with the government punishing you for exercising your free speech right.
Well, thank you. And then Dr. Braverman goes back to the whole issue that we really kind of started with today on parental rights. How do states maintain control of divorce and custody and then no federal appeal? So it seems that the states control that
Yep.
issue.
Yep. Family law, like criminal law, with some exceptions, as we have a growing federal criminal code, but like tort law or contract law, these things operate under state, are controlled by the states. And so unless you have some egregious violation of the court process that rises to a federal due process issue, you're not going to get divorce cases or custody cases in federal court, because again, they're adjudicated by states. Now, states have agreements with each other about how to enforce, interstate child support requirements or child custody agreements or what have you. And there's the federal constitutional provision called the full faith and credit clause, such that each state recognizes other states' marriage certificates, for example, or divorce decrees for that matter. Now, there's an exception to that if there's like some strong public policy against it. Some state does something really weird in terms of how it grants wedding certificates or divorce decrees or something. But generally, again, those are very marginal cases. But you're right that for 99.9% of the time, family law is and properly is a state matter.
Thank you. And then Edwin Martinez says there are natural rights granted by nature and all people inherited, civil rights that can be granted by legislation, and legal rights related to a court process. How can we draw a line between each of them?
That's a pretty good one. How you briefly, Edward, I think you said.
Yes.
Edmund. How you very pithily describe those. That's a pretty good off the cuff delineation. Yeah, sometimes people talk about political rights or civic rights. Those are things like juries and voting and participating in a town council proceeding or something like that. But that's that distinction between natural rights and civil rights or political rights, and then legal rights or rights granted by statute. But those are good ways of thinking about them.
Well, thank you. And then one last question here. Brad Hasten asks, would originalism have ruled out Social Security when the Supreme Court approved it in 1936?
I think so. I think the Supreme Court in the Helvering case and the Stewart Machine case, which were approving federal Social Security pensions and unemployment insurance, I think the Supreme Court was wrong, that the Constitution does not allow that kind of redistribution scheme, no matter how well-intentioned. And it could be at the time, I imagine, in the depths of the Great Depression, those programs would have been very popular, and FDR could and should have gotten a constitutional amendment to that effect. But I do think that a fair reading of the relevant provisions say that a federal program that simply redistributes is not constitutional.
Okay, well, we're right at the top of our hour, and we thank you so much for enlightening us today on the Ninth Amendment and enumerated and unenumerated rights and all the differences. And I know that we all learned a lot, and the audience got a lot out of this today. So we really thank you for being with us. And we want to encourage everyone to check out the Manhattan Institute where you are. And just thank you so much.
I also have a Substack, Shapiro's Gavel. That's one of these newsletters, what used to be called blogs and whatnot. And my Twitter or X handle is @iShapiro, so you can follow me there.
Well, that's great. Well, thank you so much. And we invite everybody to come back next week as we wrap up our Bill of Rights and Current Events series, and we're going to be discussing the 10th Amendment. So we will see.
I have a quick question. How do we get your Substack?
Shapiro's Gavel. Just either go to the Substack website and type in Shapiro's Gavel, or just Google it.
Shapiro's gavel, really cool. You know, I think that what we've learned today is how gray law is. You know what I mean? There's like, yeah, but this, but then there's that, and there's this, but you know, but there's that. It's really
Well, lawyers have to be paid for something.
And I will admit your use of words. I didn't want to go off track, but there were so many. I'm a writer and I love words. And boy, you've got a great vocabulary. I should have written down some of these words. So anyway, thank you.
Well, great
Well-
to be with you. Thank you so much.
Yeah, thank you. And thank you to our audience. We will see y'all next week.
Thanks, Tova and Lacey and Jewel and Jordan. Kathy.
Thank you very much. Have a great week.